Alright, we're going to get started. Thanks for being here, even though it's beautiful outside, so we appreciate it, and Ryan appreciates it. So our guest today is Ryan Calo from our own School of Law here at UW, and he is the co-director of the Tech Policy Lab, which I hope you'll tell us more about.
Yeah, I'm
today.
happy to, yeah.
So he's going to talk to us about robots as legal metaphors. So welcome.
Okay, great, yeah. So thank you very much for inviting me. So yeah, I am the co-director of something on campus called the Tech Policy Lab, and for those of you who are not familiar, we are an interdisciplinary unit that bridges computer science. One of our faculty directors is Tadayoshi Kono in computer science. Information science, Batya Friedman is our co-director in information science, and then myself in law. And what we do is we put together these interdisciplinary teams from those three schools, but also from across campus, including we've had great people from communications. Maybe some of you knew Matt Bellinger. Do you remember Matt? He was on one of my teams talking about driverless cars in Seattle and things like that. So we put together these interdisciplinary teams in order to tackle hard problems of tech policy, basically. And we feel it's critical to have all the different kinds of perspectives and training that interdisciplinary scholarship affords. And so if you ever want to learn more about it, we have a website, techpolicylab.org, and we're always putting on events and doing research. So your participation is warmly welcome. But I'm a law professor, and I'm going to be talking about the law more or less. I selected my most communication-like project of everything I've ever done in my life, which is hopefully going to make it more interesting, but at the same time, please don't hold me to the kind of rigor and methodological commitments that you're probably used to, people doing this kind of work, because I'm just a law professor, and this is a departure for me. So the way this project came about, robots as legal metaphors, was that in response to a critique of my earlier work, which was trying to lay out what kinds of puzzles that robots would present for law that were unique puzzles. This scholar by the name of Jack Balkin, he's a law professor at Yale Law School, wrote a response to my article, Robotics and the Lessons of Cyber Law, in which he said, look, Ryan's trying to do the impossible thing here. He's trying to figure out what legal puzzles some technology is likely to generate before it even really becomes part of the mainstream. In other words, in order to figure out how technology will come to be appropriated, how it will come to change society, you need to see it in deployment. And so I had analogized to the kinds of puzzles that the internet made for law. And he said, well, you can only do that, Ryan, with the benefit of hindsight. You can only do that after 20 years of seeing how we interacted with the internet. Only then can you see the kinds of puzzle. Same thing with robots. And initially I thought, well, that makes a lot of sense, and obviously what I'm doing here is somewhat speculative. But then I got really curious, and I said, well, unlike the internet, which Al Gore didn't even invent until like the 1980s, right? The robots have been around for a long time. Robots have been around in the United States in a relatively serious way since the 1950s. And no one that I could see had ever gone back and looked at all the cases involving robots in federal and state law. And so myself and a couple of research assistants, we went through and just looked at literally every instantiation of robotics, and so on that we could find. We used Westlaw, which is a search engine for law, and we specifically focused on the synopses and the headnotes. The synopses are these lawyer-generated, not court-generated, but lawyer-generated descriptions of what the main issues of the case are. And then the headnotes are the propositions of law that another court would look for. So we narrowed the scope in this way. But even so, we generated lots of cases that were about, robots were involved, but there wasn't anything robot-y about them. That is to say, it was arbitrary that it was a robot involved. And so we further refined down into cases where it really mattered that the technology before the court was a robot. And we found all kinds of really interesting cases, which maybe we can get into in the Q&A, but they were fascinating, and they begin to tell a story of how courts have come to interact with actual physical robots in the world that have created conflicts now for decades. in the course of doing this, there were a number of references to robots where there was no robot before the court, but rather where the judge was using a robot as a metaphor or an analogy. And there were so many of these, and they were so interesting that it spun a separate project. But again, law professor, I had to do a lot of reading about metaphor. I had to do reading. I actually drew heavily from one of your colleagues and her concept of polysemy and so on. But I read a bunch of rhetoric scholarship, and I don't know if Leah's here. I don't know. No. Okay. But in any event, I drew from her work and talked to her. And so, I really was a new area for me. But I just thought, gosh, there were all these interesting ways in which judges were invoking robots. And legal scholarship is sensitive to the idea that in understanding new technologies, that judges are going to be using analogy and they're going to be using metaphor. They get that, right? And so, for example, when email came around, there were all these fights over whether or not email was more like a letter or more like a postcard. And the Department of Justice actually successfully got courts to agree that it was more like a postcard, and therefore they did not need a warrant for it for a period of time. And so there's these fights, right? And so even today, people talk about, in my circles, they talk about, and probably in yours, about encryption, right? So the idea that, imagine you're trying to figure out whether it's lawful for the government to forbid encryption or require a kind of encryption that has a backdoor. Like, imagine that. How you talk about that really ends up mattering, right? So the government might be okay for the government with enough reason to to get a skeleton key to all of our cars or something like that after this tragedy in Toronto. Maybe that would be okay, or to do something like that. But if you were to characterize encryption as a form of language, well, then you start to run into interesting First Amendment ideas, right? So if I'm speaking to my friend in Italian, could the government come and be like, we don't really know Italian all that well, could you switch over to another language that we can speak? That would strike us as being a First Amendment issue. And so the way you talk about technology, it's well understood in the law and technology discourse, that really matters, and the metaphors are, in essence, what Michael Frumkin calls, they're these rhetorical weapons. And so, but what has been, that I could find hardly ever examined, was the inverse question of what happens when judges use emerging technology as metaphors when they're trying to adjudicate something else entirely. And so, again, having already gone through all these cases and surfaced the ones where robots were at issue, I then went and analyzed the cases where robots were being used as a metaphor, and I saw some interesting patterns. So first, let me just tell you a couple of examples. One example where judges would repeatedly use robots as metaphors, by the way, they do this very seldom, right? So, I mean, it's a relatively small number of these. It's not like it happens all the time. But where they tend to do it, one of the places is where they're trying to make some claim about how participants in the legal system, particularly judges themselves, are not supposed to be robots. In the sense that they're human beings and they have their own will, and they should not be treated as robots. So for example, in a case involving a judge who got very emotionally upset when a witness was telling what happened to her, and in fact got a little tearful, the opponent tried to recuse that judge by saying, you're biased, you're getting upset about this in a visible way. And the judge refused to recuse himself and said, judges are not robots, right? We're people too. If someone tells a funny joke, we're going to laugh. The same thing with jurors, by the way. You don't get to boot a juror just because they laugh at the funny attorney or they cry at a sad story. Another example, which is sort of more about institutional relationships, judges have said, we don't have to, even though we might be told that we have to follow certain statutory criteria in making decisions, we don't have to follow them robotically. Or one of my favorites is that, there's a hierarchy. Law loves hierarchies. There's this hierarchy among judges, of course, where there's a trial judge and then there's an appellate court. And the appellate court gets to overturn, especially determinations of law by the lower judge. And then often what they'll do is they'll overturn it and then they'll remand it. In other words, they'll say, you got this law wrong. Here's the case back, trial judge. Let's go at this again. right? But the question then becomes, how much discretion does the lower court judge have in light of a remand? And again, judges have said, just because we get, remanded, we're not the robot of the appellate court. So you see this sort of idea where robots are used pejoratively. People are not robots, judges are people, not robots. A second related, I think, idea is that a very common place where you saw robots being invoked was around witnesses who were being discredited because they were robotic in their testimony. Right, so the idea was that you come here, you seek asylum, you're trying to tell the story of how you were, trying to meet the standard of asylum, political asylum, how you were persecuted, how you feared for your life. But everything felt really scripted and really robotic. And the idea was that this is not trustworthy, right? This is not really the litigant, him or herself, speaking. This is just some kind of script, and you're just running a script, and you're robotic. And there were a number of such cases. And then the third area where I saw a lot of it, where we surfaced a lot of it, was in situations where courts were struggling with the idea that a person had done something wrong, but the court, for whatever reason, did not want to attribute liability to that person. So, for example, in a case called Fry from the 1950s, there was this boy and girl, I guess you could say, on a date. He could drive, he had a driver's license, and she did not. And he was borrowing his dad's car. So he decides during this date to let her drive the car and kind of tells her what she should do, and here's the pedal and everything else, and just gives her a quick sort of tutorial. And she winds up, of course, flipping the car and crashing it. And the father sues her and says, you were driving negligently, you don't have a license, and you're driving my car, and you destroyed it. And the court says, if there was negligence here, the negligence was that of this boy, this young man, because this woman the defendant was just the robot of the young man, right? And he was controlling her. She was being puppeted, and the idea was that there would be, even though a human being had done the wrong thing, driven a car into a ditch, there should be no responsibility. And there are other examples of this too. So, for example, parent corporations and child corporations, in the sense of corporations that were subservient to other corporations that own them, and they were sort of carrying out the will. And in those instances as well, liability did not accrue to the people at the bottom of this structure. It was the folks at the top. The other one was a robot corporation. Point is that there were these instances where courts did not want to ascribe liability. So, one thing to sort of notice about this is that although robots are being invoked in a number of different contexts, everything from tort law to what amounts to procedure about appellate decisions to evidence, immigration, right? There's all these different contexts in which robots are being invoked. They're almost always being invoked essentially in the same way, which is to try to show you something that while it looks like a person, right, in fact is not exercising discretion. So it's just like this, it's this way for judges to invoke something that is at this twilight between what is human and what isn't. And so in each instance, whether it's to say I'm not a robot, and judges shouldn't be robots, or it's to say that this testimony was robotic, or it's to say that this litigant was just a robot of the other litigant, or of some third party. In each instance, it is this use of the robot as though it were this pre-programmable machine. And I argue in my essay that this is both justice enhancing at one level and problematic. So I'll start with justice enhancing. There is a work by a law and literature giant. I actually had him as one of my professors at Michigan, James Boyd White. And I don't know if you've ever come across James Boyd White, fascinating individual. And he writes about this idea that in many ways justice is a form of translation. And so judges in our system, in the common law system in the United States, don't just tell you the answer, right? They have to give a bunch of reasons. They have to write down their reasons. And this is really beneficial. The typical story is, first, because, if they give their rationale, then you can figure out whether whether it makes sense and whether it's sensible, whether there's bias. You can sort of figure out a lot of things if you see their reasoning. You can challenge their reasoning to an appellate court or subsequently. And then second of all, it gives guidance to future individuals and courts about what is appropriate and not appropriate conduct. And so if we live in a rule of law, you want to know what is okay for you to do and what's not okay for you to do. And if a judge just says, this was bad, it doesn't give subsequent people in a similar situation any notice that what they're doing might be wrong, whereas if you write down the reasons, you get that. And those are typically the two big reasons why we say it's so great for judges to have to articulate why she made a decision. James Boyd White comes up with a third category, and he says, look, it's not just those first two things. It's also that justice is this dialogue between the judiciary, which has been sort of anointed to be wise and make decisions, and ordinary individuals. And that a really big part of justice is translating these highly technical legal concepts into lay terms that a smart lay person can understand. And so the voice of, for Boyd White, the voice of the judge really matters. And if the judge lays out her case in a way that is, formalistic and archaic and no person could understand it unless you were highly trained, that's not really justice, because no one can pick that thing up and sort of understand her reasoning. Whereas if in contrast she does it in this way that was really evocative and is plain spoken and everything else, that this is a justice enhancing activity. And so from that perspective, the use of robots as metaphors is quite lovely, because it gets you at this idea of translating judicial categories of liability and mens rea and all these other things that are so foreign to the average individual, and it depicts them in a way that is understandable and accessible. And so that's why I invoke Leah's work. I talk about how robots have this polysemous quality in that they are both inanimate and they both lack discretion but look like people. And so they're strategically able to be used together by a judge in order to explain his or her reasoning. And so from that perspective, it's justice enhancing. But we can talk about whether that's true or not, right? But anyway, that's my position. But then it's also problematic. And it's problematic, and I'm not sure at the end of the day, I didn't quite nail this down. And indeed, I'd love to hear your sort of feedback about this. But one of the ways it's problematic is that the kinds of litigants whom judges feel comfortable depicting as being simultaneously people but lacking discretion and intent and will tend to disproportionately be the disempowered people. Okay? So all these cases involving robotic testimony, these are all cases of immigrants coming to the United States and seeking political asylum. Okay? And what the judge detects as being robotic may be a function of the fact that they're being translated, or they're being very careful with what they say because English is not their first language, or you know what I mean? Or we've come up with these arbitrary categories that are the only thing that the law listens to, and these people are having to recite them, which feels like magical thinking to them. I mean, at the end of the day, they're scared, they fear for their lives, and yet they're being forced to talk about these very specific factors that are totally alien. If you look at the examples of where judges have talked about themselves not being robots, one of the most famous ones, and one of the ones that precipitated subsequent judges making those choices, was a black judge who was being told that he couldn't preside over a union dispute involving litigants of color versus white litigants because he had given some speech about the importance of civil rights. And so he invoked this idea of, why do white judges get to be people, but black judges have to be robots? And so there's this way in which it's sort of steeped in higher expectations around a judge at this time. And then third, and I'll end here because I'm very excited to hear your questions and of all kinds and to hear your feedback. But I mean, consider now again this case from the 1950s, this case of Fry v. Baskin, where the judge is saying that this woman, this girl, I guess, this young woman, is the robot of the boyfriend. I mean, can you imagine it being reversed? Right? Can you imagine it being reversed where the judge says, oh, this guy is not responsible for crashing the car because he's just the robot. He's under the total dominion and domination of his date, this woman whose father owns the car. It's not plausible, you know what I mean? Not then, not in that way. And so the fact that there's a gendered component to it, a race component, an immigration and othering sort of component to it, it's hard to simultaneously hard to ignore that's the context in which this invocation of robots is coming up, but also it's very difficult to put your finger on why that's happening and whether it's deeply problematic. And as I mentioned before, it also has this justice-enhancing quality to it, right? There may be more to say, but I'm going to shut up there. You know, our conventions and laws, we usually go on for 20 minutes, so you've given me longer than I usually get. But I'd love to sort of hear your thoughts and questions and everything else about the project. Yeah, Katie.
So in taking a step back, so you talk to people about robots often, right? And so robots is a metaphor in law, but robots generally. So for me, I don't know if this is because of my age, my nationality, etc. Like I am like Jetsons, Rosie, the robot,
right.
Short Circuit. Like my idea of robot is very specific, and there's probably some negative connotations associated with it for that reason. So I wonder but I know that that's not all that a robot is. So when you're talking to people about robots and they're like, you know, Rosie from the Jetsons comes to their mind, how do you talk about robots to help people understand them conceptually, and how does that match up with how robots are used in law?
That's a great question. So let me back up a little bit and say that there is no stable consensus definition of robot out there that I've ever been able to find. At one point, I did some research. It didn't go into this paper, but eventually, you know, where a research assistant and I have a lot of long-suffering research assistants. I'm sure many of you in the room do too, or are that. We looked at every attempt to define a robot that we could find in multiple disciplines. And we found a lot of different ones, but what was so fascinating was that the definition of a robot would differ on the basis of what that community of scholars was interested in, okay? So for example, electrical engineers, mechanical engineers tend to define a robot as a programmable machine. And the reason seems to be something about the idea that they're engineers thinking about a machine that is dedicated to one particular purpose versus something that's more versatile that can be programmed to do a range of things. You see what I mean? So like a dishwasher, washing machine rather, is not a robot because it's really only doing the one thing, whereas programmable is the idea of it being doing multiple different things. That idea of a programmable machine seems to be what these judges are thinking about when they're thinking about robots. They have this idea of it's programmable, it's a robot, it's at someone else's thing. Versus in the humanities, again, English, media criticism, film, we found many a very different set of definitions that coalesced around the idea that robots were fake people. You know what I mean? And in that sense, robots were kind of spoken about in the same breath as Frankenstein or the Golem or something. You know what I mean? Or zombies. I mean, robots were just interesting because they exist at this twilight between person and object, and what was interesting about that was like the way that people have this duality, right? So the definition had to do with the kinds of questions these folks were ultimately asking. But the definition that I like to use and what I use in my own research is what you see largely in the computer science and artificial intelligence context. Computer scientists tend to talk about robots as having three qualities that distinguish them from previous and constituent technologies. And those are, number one, that the robot is able to sense the world around it. And then number 2, that it's able to process what it senses. And then number 3, that it acts upon the world. And this is, of course, derived from the old sense, think, act paradigm from psychology decades ago. But they've co-opted it for this purpose. What I like about that is that that maps onto the kinds of questions I'm asking, about this environment. How does it perceive the environment? When it does its thinking and makes a decision, how should the law treat that decision? So that decision accrue to the designer of the robot itself. If to the designer of the robot, how much knowledge should we ascribe to that designer? What if there's emergent behavior that no one anticipated? And then the idea that it acts upon the world. So a laptop with a camera, right? It senses the world and it processes what it senses, but it doesn't act upon the world. What's interesting when you start to act upon the world, especially physically, is that's where you start to get the kinds of harms that the law is seeking to mediate. So it's a long-winded way of saying basically that in my own research, I take this relatively arbitrary definition from computer science of robots. I lay that out right up front. This is what I'm talking about. And I do it because it is those qualities that wind up driving the discussion in the law. Now, these judges, ironically, I guess, ironically is the right word, but these judges actually are, when they're invoking robots as metaphors, they're doing it for a different purpose. They're not trying to figure out what the interesting legal issues about robots are, right? In reality, they're trying to show you that a robot is this thing, this person without discretion. And so they actually gravitate more towards maybe a humanities or even electrical engineering, mechanical engineering definition for that purpose. I think that's going to shift, because I think that when these judges start to confront really advanced robots that are behaving in ways that are strange to them, that's when you're going to start to matter that robots can process what they see and act on it. I was a little long-winded in answer to your question, Katie, but yeah, go ahead.
So first, I wanted to say, in regards to that Fry case, I actually had the exact opposite reaction as you said. You would never even think that's true. That was what I thought was going to be the case. In that the judge would have allowed that, like, the boy was just under his conditioning. Boys would be boys, like, exactly like how that judge ruled, like, affluenza as part of cultural conditioning, like, and that's robotic programming. It could be thought of. In the same way that I was really surprised when you said that the discredited witnesses were always like disempowered people. And it made sense when she talked about it, but the first thing that I thought of was Mark Zuckerberg's testimony when he was in Congress, because everybody like automatically just like thought of him as a robot, right? The question I want to put forth though is, so you started this talk with a discussion about how you're trying to anticipate where policy and law would go with robots, and I'm wondering if you think that the way that these metaphors are constructed and thought of in law or just widely will have an impact on how the judicial system tries to regulate robots.
Those are all two fascinating points and then a great question. You're right. I mean, I also watched Zuckerberg's testimony and thought to myself, this is really robotic. And I think people criticized him about that. I think maybe the ramifications for him are going to be different because of his place of privilege, But again, what I'm trying to convey is that the cases where people's credibility was disparaged to the point that they were not allowed asylum or they were not allowed to immigrate or whatever it happened to be, they tended to be these marginalized people. I have to think a little bit more about the idea. I did not see social conditioning as an example of roboticization, but for one example, which I didn't mention, which there was an example involving a cult, and these people who had to be deprogrammed from the cult. And the dissent said that when they were acting under the influence of the cult, they weren't just robotically carrying out commands, right? So that's a very specific, intense form of social conditioning. But that was described as robotic in its tendency. But I haven't thought about the sort of boys will be boys kind of point of it. Anyway, to answer your good question, the editors of this piece really pushed me to talk about whether the growing disconnect between the mental model of judges thinking about robots as being programmable by a third party and the actual reality, which is increasingly one in which robots can do things that you wouldn't expect whether that would create problems. And, again, at the sort of cajoling of the editors, I wind up making gestures to that effect. But the truth is that, individual judges are pretty good at getting their mind around something when they have litigants to help them and experts to help them. And so if you do, maybe initially, right, the judge will say, well, this robot that ran into this woman pedestrian, you know what I mean? Like it was just programmed to do so, right? And then only initially. And then what'll happen is that litigants will explain how it actually works and all this different stuff. And you even saw that with the Supreme Court's discussion about the Microsoft Ireland case involving how Microsoft ends up retrieving information from servers that are in Ireland. Initially the judges were asking these goofy questions about like, well, what do you mean? Like a little robot goes there with its little hat, and you know what I mean? And but over the course of like even 5 minutes of oral argument, they got it. So I'm actually not deeply worried about that. But I do think that it will pose these challenges. I mean, I'm more worried about the idea that they'll get it, they'll see that like this was emergent behavior that nobody predicted, and then they won't have a good way to ascribe liability, because in law we don't ascribe liability if you can't foresee the category of harm that occurred. And then there'll be these victims without perpetrators. You see what I mean? So I'm more worried about their inability to grapple with the law than I am with the technology. Yeah, there isn't really. I mean, so people talk about animals and people talk about all kinds of things, but the truth of the matter is that if you keep a shark in a pool in your backyard, right? You're going to be held strictly liable if someone goes into that pool and gets bitten by the shark, right? But if the shark, gets up on its little flippers and commits mail fraud or something like that, you know what I mean? And you come home one day and someone comes and says, I've been defrauded by your shark. That's not something you'll be strictly liable for because it was not predictable, you know what I mean? Like, the reason sharks are dangerous is because they swim around eating things, not because, they're smooth talkers. You see what I mean? And so like the metaphors are difficult. The analogies are difficult. I read about this extensively in another piece called Robotics and the Lessons of Cyber Law, which is what that law professor was reacting to when he said you can't predict what's going to happen. Yeah.
So I had a couple of questions just about sort of how you're collecting this and what you saw when you looked at it all. So less about the tech and more about sort of the words themselves.
Yeah.
Because if you call it, if it occupies a noun versus an adjective or adverb position, it's sort of if it's a noun, it's a pretty high metaphorical commitment. You are a robot. Okay. If it occupies an adverb position, it may or may not. It might be a false positive, right? We use robotically as an adverb probably more than we say you're a robot. Okay, one bigger commitment. So I'm wondering if there was something there. But as I hear you talk about the 50s case, we're looking at maybe 70 years. Do you see any sort of trend? And I'm assuming the judiciary's not the youngest group.
Right.
So you're kind of expanding that range a little bit.
Yeah.
So, I mean, what then are sort of the trends over time in how they're talking about robots?
Yeah. So, well, first of all, let me say that point you just made about how much of a commitment you're making to the metaphor, is precisely the kind of nuance that was lost on me in this project. You know what I mean? The kind of reason why you are communication scholars and I'm a law professor. But that said, I completely agree with you. I think that's fascinating, right? Because there were instances where it was like someone was behaving robotically, and other instances where someone was the robot of somebody else. It did not, as I think about it, while the commitment to the metaphor may have varied across contexts, I did not perceive a historic trajectory difference in that. I'm trying to think of specific examples. The examples came from lots of different places, but actually it's consistent. Something I know more about. I'm gonna pivot to something I know more about. So it's interesting because when I had far more data around cases involving robots and far greater capacity to understand what work the object was doing. And one of the things that I saw was that over the years, there were all these different instances where robots would appear before the court, not literally, but robots would be a matter before the court. And the question would be, to what extent are these robots adequately substituting for something that a person did. And some of the cases were from the 50s, and some of them were from the 90s, and some of them were from 2000. I mean, and they all asked the same question. So for example, in the 1950s, we began to import robots from Japan, little toy robots from Japan. And for historic reasons, the tariff, the tax that was charged on toys, differed with respect to dolls than other kinds of toys because of some agreement we'd made with Europe. And so the folks importing robots wanted them to be dolls, and the definition of doll was that a doll represents something animate. Okay? So they argued at length about whether a robot represents something animate. Is it a mechanical person? What is it? Whatever. And they went over and over this. And finally, the court decided that although a robot represents something animate because it's a mechanical person, right? A toy robot represents a robot, which is inanimate. Okay? So that's a question from the 1950s. Okay, about a robot. Fast forward to the mid-90s. And does people know like Chuck E. Cheese, like the Chuck E. Cheese restaurants? And you know how I'm seeing a hand over there. And they're actually decommissioning these, I guess, one by one. But there historically were these bands, these robot bands that would play at the Chuck E. Cheese. And you'd go in there and all of a sudden there'd be some announcement that, Chuck E. Cheese and his band would come out and they'd play like a set, these robots. So in Maryland in the 1990s, an enterprising tax authority, again, tax is the question, comes forward and says, well, looks to me like you guys have a performance here, and you need to pay a performance tax on food, And then the court had to decide whether or not robots could perform for purposes of a performance tax. And they went through all these sort of amazing, sort of tortured conversation about what it was to perform. And ultimately they decided that performance had to be spontaneous, and that robots were incapable of spontaneity, and that these were just like elaborate jukeboxes, you know what I mean, and so on, which would not be true of contemporary robots. But point is, these kinds of questions are very similar to each other, right? In another case involving a completely different area of law, the question was whether a robot version of Vanna White violated the rights of publicity of the actual Vanna White. Because Samsung made this ad, not long ago, made this ad of robot Vanna White, and it was making some joke about the future and how there'd still be Wheel of Fortune, but it'd be this robot Vanna White. And the court had to decide whether a robot version of somebody was that person for purposes of right of publicity. And the court went through this, again, these analyses, and the dissent completely disagreed with the majority. But the question again and again was this idea of substitution, of social valence, right? And so, it seems to be that with respect to this question of how robots seem eerily like us, there isn't a lot of delta between the two. But I will go back and look again. And I really like your point and take your point about just how committed, and the noun in particular, saying this person is a robot is straightforwardly a metaphorical use versus just describing them as robotic. I definitely agree with that, yeah.
So do you think that when the robot metaphors are used, I'm thinking now about the disenfranchised or unempowered peoples that are being referred to by robot metaphors.
Mm-hmm.
Do you think that that's a way of talking about them or describing them as having not full moral status in a way that is not quite as embodied as calling them an animal? Do you know what I mean?
Yeah. I don't know. So in what I say in the paper, and again, I don't have great, thick reasoning behind this. You know what I mean? But what I say in the paper is basically that maybe it feels easier to the judge and the judge's anticipated audience to refer to a person who is an other, right, as being robotic, as being a robot. Now, again, you had a different take than I did, for example, about this woman. But I thought to myself, that might have struck a 1950s judge as plausible that some guy's date is his robot, like he's responsible for her, at a time when like you were your husband for purposes of lawsuits. Do you see what I mean? Like this was a time when, so it might have seemed more plausible, and that you wouldn't see the invocation of that metaphor were the genders reversed. You have a different view that I think has to do perhaps with the idea that maybe boys will be boys as a kind of implicit claim of being determined by one's culture. So, for me, there was less resistance to both invoking a robot as a metaphor for someone who was an other, and the judge anticipated that you'd understand. You see what I mean? But it doesn't work perfectly, right? Because again, well, let me say it another way. The places where the use of a robot was negative, right, was also interesting. So again, this person saying judges are not robots is meant to invoke a kind of revulsion in you. You know what I mean? Like, oh, I didn't mean to suggest that judges are robots. You see what I mean? And so it's this idea, and it's like, as applied to a powerful, judge, presiding over a person that we have imbued with this sort of qualities and wisdom to be, an adjudicator, and that the idea of saying that person was a robot was an anathema, right? But it's easy to say this other person is a robot. So I don't know, you know what I mean? But it doesn't track perfectly, if you notice. I mean, it doesn't track perfectly. It's just a speculation on my part. Yeah.
On your point about the characterization of a witness who's in a disempowered position as robotic,
Yeah.
what comes to my mind as a possible other factor that you might look at is the outcomes of trauma, the effects of trauma on somebody's communication style and pattern, and the coaching that prosecutors do with victims who've been traumatized to get them to stabilize and be able to speak in any kind of coherent way through their trauma
Yeah.
about something that is traumatic. It requires exacts like that. Say this, stick to your point, say that, because if you go off script, the prosecutors they will absolutely fall apart.
Yeah.
So there's
Sexual assault cases,
so
yeah.
That's a known area of, there's a lot published about legal coaching of traumatized witnesses, how to make it through a trial. I wonder if there's any, they would not be saying, be like a robot, but as they coach them to speak through their trauma and talk about their trauma, or whatever is creating them to be, creating the conditions of this extreme disempowerment, it could very much appear to look like this. There's also then, so that's sort of the trauma area. The other area would be dissociation. So what is it taking, what's happening, if you look at psychology,
Yeah.
what is having to happen in their minds to make it through that interaction in court. And there's very plausibly some level of dissociation, which manifests as, so this talking like robotically, they're dissociating in order to. So two different other areas of literature that may explain.
It does help explain. I mean, the takeaway, so this really would bolster the sort of case for this, but the takeaway is that due to these mechanisms that people who have experienced trauma might need to use, it has the unfortunate effect of making them appear making them being received poorly by a system about facts that end up being pivotal to their case, right? And let me just if you're interested in this, right, the reverse is interesting too. So one of the things that we talk about with our students who are interested in appellate advocacy, and the movies that we show them and the things that we show them, and you know what I mean, is that the best advocate will get in front of these three, say, federal appellate judges who are appointed by the president and confirmed by the Senate, who almost inevitably went to one of the top 10 schools in the United States. You know what I mean? So is to feel like you're having a conversation with them. That's what we tell them. You know what I mean? So just imagine that you're at a dinner party and you're having an interesting conversation with this federal appellate judge, right? And those of us who went to dinner parties with federal appellate judges, because our parents were professors or something like that, well, we do feel comfortable in that kind of environment, but a person who has never had contact like that before would not. And so our strategies for success for people with a lot of privilege and a lot of experiences, and we just rattle that off as though it were no big deal. Like, you should just, whoever you are, just treat this person like a, you know what I mean? And so what works, rhetorically in the legal system often tracks privilege in this very strange way. So, but anyway, I love your suggestions. It's something I'm going to do a deeper dive on. Yeah, you had a question, I think.
I had a question. It's been hit on in a couple ways, but I'm wondering how you conceptualize emotion playing a role in this at all, in terms of what robotic means behaviorally.
Thanks, guys. See you soon.
Whether
I know you have class, yep.
to be without emotion, to be a robot, and what role emotion may play within law. Have you conceptualized that at all within your thinking surrounding that?
No, yeah, go ahead.
Well, I'm just thinking about some of the literature on the way in which emotion can be used to dehumanize. It seems to be flipped here, right? So some groups are labeled emotional, and that's a way of delegitimizing their points or them, right? And we may instead underscore or privilege reason. And it seems like within the context that you're describing, reason would be something that's privileged, right? Emotion not. And so it's not really formed, but I'm seeing that emotion may be playing a role here because it is because of the way it's tied into being robotic. I just don't know if you thought about that.
Yeah, I haven't. I mean, so one thing I thought about was that isn't it interesting that almost every single invocation of a robot that I came across, there was one exception. I'm hard pressed to even reconstruct exactly. It was in passing. Every one of them is negative. You know what I mean? No one is saying, gosh, like this person was so logical that they were like a robot. They were, you know what I mean? There was one passing reference to the idea that a robot judge or a robot system might be less biased. This was like in passing, you know what I mean? But overwhelmingly, every single instance I saw was negative. And that is interesting in light of the way in which law tends to see itself as privileging the rational. I will say that one of the places that emotion factors heavily in legal discourse is around the reliability of testimony. And that's something that's touched upon here. But the truth is that even today, even to this day, in courts around not far from here, witness testimony is the gold standard. You know what I mean? If someone gets mugged and they're trying to, you know what I mean? Like it says, witness testimony is the gold standard. Notwithstanding just mountains of evidence suggesting that in a highly emotional, sort of fearful state, or that you cannot reliably identify people, or you know what I mean? I mean, it's just like loads of evidence about this, and yet the law has pretended that it's not the case, And so there is this sense in which law systematically fails to factor in emotion. So it's somewhat ironic that if you display zero emotion, the way that the law personified, then as an individual litigant within it, that you would fare poorly. Another example of a place where emotion actually plays really interesting. So I teach tort law, right, where you sue another person for a reason other than contract, And there's two different standards that you might sue somebody, say if a product hurts you. One of them is strict liability, the idea being that you don't even look at whether there's been fault. As long as the harm occurred to you and it was causally related to what, you know what I mean? So like one Coke bottle comes off the factory wrong, and you pop open the top and a cap hits you in the face, and we don't ask about whether Coca-Cola did the wrong thing, you're just liable. The other possibility is what is negligence. And negligence is the idea that there was a standard of care that you were supposed to meet and you fell below that standard of care. Often litigants will bring negligence suits even though they're harder to prove because they consider them to be hot instead of cold. Because if you can show negligence, then you can show that the defendant did something wrong. And you will get a jury, hopefully, who will see this story as not being a story about how we're just holding these people accountable because they're the best cost avoider, some kind of economic rationale, but rather they did the wrong thing. You know what I mean? And so emotional valence ends up mattering in terms of what standard you apply. So there's places it factors in, but I've not done a systematic assessment of it. I do think that there are some tensions, and I think they particularly have to do with the tension between what we expect of the system as a whole to be rational and emotionless and so on, Vulcan, and then how we treat people who act like that within the system. So, Anything else? I'm right across campus, so if you think of anything, else, please, get in touch and email me and check out the lab's work and let me know if I can ever be of any help to a project of yours that looks at law or policy. But yeah, please.
So it sounds like, I'm really interested in these examples where people describe themselves as robotic or not. Maybe describe themselves as not being robotic, right? As this idea, and it sounds like it's like judges saying like, I'm not a robot, right? I don't have to act like a robot, or we don't have to act like a robot, right? I'm interested in the way in which like the way in which that's invoked and like what it's invoked to do, right? The sense in which like there is this expectation that these people are supposed to be. I'm not entirely sure where the question is here, but it was ending, so I tried to get it out.
Yeah.
But
I didn't mean to rush you, by the way.
But there's this idea that like that the judge will say like well basically like although their job is to be kind of rational and to apply the law be fair and all these sorts of things, right, that they acknowledge that they're also people, and that's something which they should be allowed to act upon in certain ways. And so I guess I'm just curious about like the kinds of things that justifies and the kinds of role that plays. People are invoking it in a way that presumably suggests that they think that it's having a good effect, right? That they don't have to just mechanically apply this thing as written. They can understand that things are different, right? Is that how it was invoked in those cases?
Yeah. So in every case where a judge is invoking robots as a foil, right? It is to confer upon that judge more discretion. And so the basic idea here is that while we're simultaneously invited to consider judges to be impartial, and logical, like that's something that we value in judges. There's people like Benjamin Cardozo write whole books about this, and about the habits that judges, over time accrue and why they're beneficial and things like that. Felix Cohen talks about synoptic vision. You'll be able to see issues from both sides. All this really cool stuff. So we expect that, right? But at the same time, we don't want to feel like justice is being dispensed by some computer. And so the idea of a robot is like a bridge too far. And so they use the robot to say, look, you don't want a justice system that is, you don't want a justice system that is robotic, or that is so formal, so automatic, that there's no possibility for leniency or lenience, or there's no possibility for human values. You know what I mean? It's like people who bemoan the move from umpires to laser cameras to make sure that that's in the strike zone. You know what I mean? People say like that's not baseball, right? And so so here the idea is that while you do want these qualities in judges, you don't want to take it too far, and the too far is supposed to be the robot. You know what I mean? The robot becomes the incarnation of taking that principle too far. And indeed, one of the things that I study, I know you think about this stuff too, is, and presently what I'm looking at has to do with the use of algorithms in the dispensation of justice, or artificial intelligence algorithms, whatever you want to say. My lab has money from MacArthur, and I'm involved in this sort of dialogue around this, and I know others are too. And one of the principal tensions is the idea that what artificial intelligence is good at, or what it's supposed to be good at, is it's supposed to be good at efficiency. Like the way that AI is invoked in lots of different contexts is to be more efficient. And yet, at the same time, the thing it's terrible at is making you feel like you're actually being weighed individually as a person. You know what I mean? And so there's this tension that was identified by among others, Jerry Mashaw, this concept of bureaucratic justice. And the concept of bureaucratic justice says that on the one hand, you want the affordances of a bureaucracy because it's efficient and it has expertise and you know what I mean, and it has certain kind of safeguards involved in it. So you want that, but you also want it to have a human base. And so, the central tension of artificial intelligence and the use in the justice system is this contrast between between the possibilities for efficiency that this new set of technologies brings to bear, but also the alienation and the way it gets away from what Robert Summers calls process values, which are the values that don't necessarily get you closer to they don't always advance the best result, they don't always get you to the best meritocratic result, but they're things that make you feel like you've been heard and you have dignity and lend legitimacy to it. In fact, there are certain things that actually stand in the way of getting to the correct result, but are there for dignitary reasons, like for example, or for some other reason. The exclusionary rule with the Fourth Amendment. Idea is that police officers violate the Fourth Amendment, they get some information, the information is true, it's totally relevant to the case, right? But nevertheless, it can't get in the door. And the reason for that is not to get a better result, it's actually to disincentivize police from doing that. Anyway, I'm going on a little bit of a tangent, but my main point is that that tension is manifest, which is that we want our justice system to simultaneously be impartial and logical and efficient, and you know what I mean, and all these different, but we also want it to feel like personal and dignity conferring and so on. And robots are a very interesting place where that dynamic meets. Yeah.
I know there's a lot of other geeks in the room, so I have to ask the Android question.
Oh, sure, yeah.
So with all of these, you said all the invocations, except maybe one exception, were negative. A robot is negative, robots don't have agency, that's kind of the metaphors that are used.
Yeah.
So if in some potential future where we do have mechanical life forms, like Data on Star Trek or Blade Runner, or those kind of beings, do these kind of metaphors set up an automatic lack of agency or an assumption of lack of agency in the future, and for life forms like that possibly should be considered having liability and agency individually? Like, is this creating a bias in the legal literature from the start for any potential future like that?
Well, let me answer that two ways, right? So number one is that, again, I believe that judges will be capable of being educated. You see what I mean? And so if you come forward and you show them, they have this idea of basically this walking, vending machine, and you show them something a lot more subtle and interesting they almost cannot distinguish from a person. And you tell them how it works and you explain it. You know what I mean? Like, judges can get that eventually. And so I'm not in a long-term way worried that the contemporary prejudices of judges will come to inform this. But the bigger problem, again, is the law, which is that the law, to anthropomorphize, the law has a set of assumptions about human biology. So, for example, we might be hard-pressed to deny that some replicant from Blade Runner shouldn't have a set of rights, fundamental rights, whatever they happen to be, to procreate, for example, suffrage, but when you can make thousands of them, do you see what I mean? In the case of an AI, where procreation means, binary fission or whatever, being able to separate out instantaneously into two entities or combination with another, it just fundamentally breaks our ideas about it. So for example, imagine that you have a robot that's built in 2050, okay? Built in 2050, and the robot is really smart, and everyone loves this robot, and there's no real way to differentiate between this robot. It's like Data, everyone loves Data. And it's built in 2050 in the United States, and it decides it's going to run for president, right? Well, do we make it wait 35 years? Do you see what I mean? Even though it's fully grown and fully and getting smarter all the time, because that's what the Constitution says about the age of. So there's all these baked-in assumptions to the law that would be totally broken by androids and the like. And so, to me, the bigger problem is how do we systematically go through the law and re-examine these often embedded assumptions about our biology, and so. But we're doing it. We're doing it. So if you look at the monkey selfie case, like this, have you guys seen this? Recently a court ruled that while an animal could have standing in theory, under the Constitution, that the specific Copyright Act does not confer standing on non-human persons. Do you see what I mean? And that has maybe repercussions for robots who claim that they have copyright in something that they invent. You know what I mean? Anyway, it's usually the law, not the technology that gets tricky.
Biology might not even be a determinant. A corporation can be a person under the law. Why can't
Yeah, so that's, I mean, I think it's tempting to look at it that way, but I mean, the truth is that a couple things about corporations. So number one is corporations don't have the full panoply of rights. You know, they have specific rights in particular contexts, and most people look at it, see them as derivative of the shareholders or the principals, right? So a company doesn't get a vote. I mean, in all kinds of complicated ways, they get the only vote, right? But I mean, special interests. But I mean, I just mean like they don't get a physical vote, even though suffrage is a universal right. A company doesn't get to procreate because I get to, you know what I mean? And so you're right, that in some selective community, and indeed, you know, it's tempting to think like, you know, in the past, we've conferred certain kinds of legal status on ships, on parcels of land, but they're always instrumental. You know, they're done on purpose because we don't know whose ship this is, and so the ship's going to have to represent itself until we figure out whose ship this is. Or you see what I mean? Anyway, but yes, you're right. There absolutely are selected rights in particular contexts that are given to non-human organizations. Yeah. Cool. All right. Well, I'm going to go pick up my daughter Ramona at daycare. But thank you very much, guys. This is fabulous. And